Okay, it's 12 o'clock on the spot, and so we're gonna go ahead and get started. So I wanted to first, thank everyone for making the time and joining us on this CLE today. I have the pleasure of being with Kendall Lewellen, who's an expert on housing law, and so I'm honored to be here with her. My name is Edith Chavez, and I'm the interim program coordinator for Arkansas Access to Justice, and today I'll be your moderator. Before I get started, I would like to touch on a few housekeeping items. First of all, for those attending the CLE wanting to receive credit, later this evening, I'll be sending out an email to the attendees who completed the 60 minutes. The Office of Professional Conduct does not award professional programs, does not allow partial credit. So you have to attend during the full 60 minutes in order to receive the credit. The email will also contain the materials and the certificate of attendance. And if you, for some reason, join with your cell phone, I will be sending out, please send me an email, and then I'll be able to tie your cell phone number along with your name so that you can receive proper credit. And finally, I'll leave 5 minutes at the end of the presentation so that we have a Q&A, that we can have a Q&A. I know Kendall said that there's a lot to touch on, so we may go a little bit over the hour, but we'll try to keep it as timely as possible. And so without further ado, I want to introduce our presenter, Kendall Lewellen. She is the Housing Area Subject Manager at the Center for Arkansas Legal Services. Kendall attained her BA from Hendrix College, and her JD from the William H. Bowen School of Law. She's a proud member of the Arkansas Access to Justice Commission. Her work is centered around affordable housing, landlord tenant issues, and rights of low-income Arkansans. Lately, you might have seen her face because she has been spotlighted on several news channels, and it's an honor to have her presenting this CLE today. Welcome, Kendall, and the floor is all yours.
Thank you so much. Edith, I'm going to go ahead and share my screen and get started, but if you want to throw out poll questions, just let me know.
Okay.
1 second. All right. Well, as you just heard, my name is Kendall Lewellen. I'm the Housing Subject Area Manager at the Center for Arkansas Legal Services. I'd like to thank the Access to Justice Commission and especially Edith for pulling this together today. And I'm going to be talking about Arkansas landlord tenant law. But just so that you know who I am and who I work for, the Center for Arkansas Legal Services is a nonprofit law firm. We represent low-income Arkansans in civil or non-criminal cases. And our service area is this area highlighted in blue. And you can call this phone number and you can speak to an attorney over the phone and receive free legal advice, assuming that there's no conflict of interest and the person meets our income and other eligibility requirements. In the northern part of the state, this area is served by Legal Aid of Arkansas, our sister organization, and generally speaking, our organizations help people with family law issues, housing, consumer protection, helping people get and keep government benefits that they're legally entitled to, and sealing criminal records, among some other things. Today, I'm going to be talking about eviction, habitability, or health and safety standards in rental housing. I will also touch on some specific issues to income-based housing, and I will give y'all some resources so that you guys can do research on these issues on your own. The legal process to remove a tenant from a rental property is called eviction. People mean a lot of different things when they use the word eviction. Many people believe that when a landlord gives a tenant a piece of paper called an eviction notice, that the landlord can then call the police on the tenant for trespassing if the tenant remains in the home. That's mistaken. And there is a very specific legal process known as eviction that a landlord must go through to remove the tenant from the home. Edith, this may be a good time for the first poll question so I can kind of gauge what people's professional background is.
Absolutely, absolutely. Let me go ahead and share my screen and do that poll question. 1 second. Okay. Okay, I went ahead and did the poll. Let me share my screen so we can see that. Okay, if you don't mind answering this question, who are you? We want to know how much knowledge you have. We're going to give 1 minute to answer this question. Okay, we have about 76% of people have answered the question. All right, we have 88% of people. There's a few more people that are still missing. All right, and we'll end the poll. So Kendall, it looks like most of them are attorneys in private practice, and we have with 44%, and then we have 15% of our attendees are government attorneys, and 8% attorneys for a nonprofit, 10% corporate attorneys, 4% are core personnel, and I guess there's no law students today.
All right then, good to know. Okay. The reason why criminal trespass laws don't apply to evictions is because tenants have something called due process rights. When you have an interest in property, and among other things, that means that the government generally cannot take it away from you without giving you notice and a right to be heard beforehand. So therefore, criminal trespass laws have been found to not apply to landlord-tenant relationships. The landlord cannot get rid of the tenant by simply changing the locks, shutting off utilities, or similar measures outside of the court system. A landlord who does this might be sued and can be sued for something called forcible entry. Informally, I will sometimes call this self-help eviction, because a landlord has to go through a very specific court and legal process in order to evict a tenant if the tenant does not move out voluntarily. Throughout this presentation, I'm going to talk about something called a writ of possession. And if you're not a practicing attorney, this may seem very foreign to you, but that's simply a court order where a judge or a clerk in some cases orders the local sheriff's department to remove a tenant from the home. The eviction process in Arkansas is called unlawful detainer, and this is where you can find it in the code. This is a special process created by statute, otherwise known as a special statutory proceeding. And so there's a special process that allows landlords to get relief, usually in the form of getting rid of a tenant, faster than the rules of civil procedure would normally allow a lawsuit to proceed. However, these cases are still subject to the rules of civil procedure to the extent that they're not in conflict. And these cases should be filed in circuit court. The circuit court does have jurisdiction over these cases. However, district judges may hear the cases through the reference process. This is a process in Arkansas where a district judge may handle all or part of a case that still remains in circuit court. As a practical matter, what this means is that you have to file the case in circuit court, although you may actually end up dealing with a district judge. I have noticed technically the parties are supposed to consent in order for a district judge to hear the case through the reference process. And there's a form that the parties are supposed to sign and return to the court. Sometimes courts may simply refer the case without the parties turning that in if they don't object. And depending on what's going on in the case, you may want to allow that to happen. If you try to look up the statute to evict a tenant in Arkansas, you may be surprised to find that there's actually a totally different eviction process under the Arkansas Residential Landlord Tenant Act. We will not be focusing on that today because it is rarely used in the state of Arkansas. There are a few counties where it's used more often than others. But if you're an attorney, I advise against filing a case under the Arkansas Residential Landlord Tenant Act or ARTLA for a few reasons. There's kind of an unresolved dispute about who has jurisdiction to hear those cases, district or circuit courts. And there are also a number of issues related to service. And ARTLA cases generally require a hearing, which may not be very efficient if you have been hired as private counsel for one of these. Back to the unlawful detainer process. This is an interesting process that I sort of divide into the pre-hearing stage, the possession hearing stage, and beyond. What happens after the hearing on possession? There are a number of reasons why you could evict a tenant using the unlawful detainer statute. And those are going to be if the tenant is behind on the rent, if the tenant is holding over or continuing to live in the home after the lease has expired, if the tenant has caused property damage, is creating a nuisance, for example, excessive criminal activity at the property, or if they're simply remaining in the home after the landlord has made a lawful demand for possession. And what that would mean is that the landlord has given the tenant an eviction notice saying, be out by X date for this reason. And you may notice that breaking the lease or breaching the lease is not actually listed as a ground for eviction. Not every single breach of the lease is going to be serious enough to give rise to an eviction, but this last ground of, staying in the home after a lawful demand for possession, I think that can be used as a catch-all to cover, material breaches of the lease other than non-payment and the other expressly listed grounds. The process is always going to start with an eviction notice. Most of the time in Arkansas, you're going to see a 3-day notice telling the tenant to be out in 3 days based on non-payment of rent. If the tenant has a month-to-month lease, that tenant is generally going to be required to 30 days notice that the lease will not be renewed and the tenant needs to vacate. However, federal law under the CARES Act now requires 30 days notice to vacate in cases based on non-payment of rent when the home is funded by the federal government. I'm about to talk about this in a little bit more detail. This is a relatively new development that affects a lot of rental property. And even though these are in Arkansas, these cases are brought in Arkansas courts, you still have to follow federal law. So what's going on with the CARES Act? You may have heard of the CARES Act when the eviction moratorium was in place a few years ago. And that moratorium, there were a few of them. That one expired. However, different parts of that law remained in effect. And one of those is a notice requirement in evictions based on non-payment of rent. 30 days notice is still required for evictions based on non-payment in properties that are covered by the CARES Act. So you may be wondering, what is covered by the CARES Act? Well, it's actually a very significant amount of rental property. The Federal Reserve, I think this data is from 2021, but they estimated that it was anywhere from 28 to 46% of rental units in the United States. And so it's going to be property that's paid by the federal government in some fashion. And that's going to include almost all income-based housing, such as housing that's funded by HUD, like public housing or Section 8. It could also be income-based housing through a tax credit or that's funded by the USDA through its Rural Development Program. Or it could look like just a normal home with a private mortgage where the rent is not based on the income, but that mortgage is from the federal government, or it has been like sold to Fannie Mae or Freddie Mac. That can be quite complicated. And I will give you some tools at the end of this presentation where you can like look up if the property has a federally backed mortgage, at least if it's a multifamily property. There are some databases where you can go and look that up. But the takeaway from this is that there is a federal 30-day notice requirement that affects a large portion of rental property. So if you're not sure if your property is covered, I would probably just err on the side of giving the tenant 30 days notice in case. But if the rent is based on the tenant's income, it is almost certainly covered. Okay. At the beginning of an unlawful detainer case, the tenant should be, served with a number of things. It starts with the notice to vacate with the time limits and grounds that we just discussed. If the tenant stays in the home after the deadline on the notice expires, then the landlord can go and file an unlawful detainer case in circuit court, and that landlord should be represented by counsel if the place is owned by a company. And I have a question. We received a question about that before the presentation began that we'll address at the end if we have time. But the tenant, after the lawsuit is filed, should receive a packet of things, including a complaint, a notice of intention to issue writ of possession, a summons, an affidavit from the landlord. A copy of the lease and the eviction notice should also be included as exhibits. Generally, when you sue somebody over any kind of breach of contract, you need to, include the contract itself, or it could be vulnerable to getting dismissed. And the notice of intention to issue writ of possession, if you don't do these cases already, you might be wondering, what is that? Well, if you look at the unlawful detainer statute, it actually gives you a sample one with some sample language to include. It's basically a notice that the clerk signs off on. It's included with all of the paperwork that the tenant receives, advising the tenant of some special deadlines that are not, covered by the general summons that a tenant would get, or that, a defendant would get in a civil case. After the tenant is served, the tenant has 5 days to file something called an objection. And those 5 days do not include Sundays or legal holidays under the statute. And the objection is different from an answer. It is oftentimes combined with an answer when you're dealing with a tenant who's representing themselves in court. It all sort of blends together in those cases. But the objection needs to sort of plainly state that the tenant objects to the eviction and the reasons why. But the tenant still has 30 days to file a full answer and any counterclaims that the tenant may have. I find it a good practice to just combine the answer and objection into one document. It saves me time if I'm representing a tenant, and if you're advising a tenant who's representing themselves in court, you might as well kill two birds with one stone and just go ahead and get both of them done. There's no bond required for either party at this stage of the case. There used to be a requirement that in order for a tenant to object, they had to post a bond, and that was repealed. That's no longer the case. But if the tenant files nothing, the clerk can then sign off on something called a writ of possession that we just talked about to allow the sheriff to remove the tenant from the home while the case is pending. Now, there's a bill that just recently passed the Arkansas House and Senate that will require a court order for a writ of possession to be issued. And this hasn't gone into effect yet. I think it'll go into effect like 90 days after this legislative session ends. But this will be a change because it'll add an extra step to the process. So, the judge will have to actually direct the clerk to issue the writ now, which it'll be good for tenants for a number of reasons, and perhaps for court staff as well, because it will allow for more judicial oversight over the process. So what happens if a tenant does object? What happens then is that the case is going to be set for a temporary hearing on the issue of possession. The tenant needs to be served with notice of that hearing by certified mail. Okay. This is the temporary hearing on possession where the landlord needs to prove that they're likely to succeed in the case. And if that happens, if the landlord, proves their case, they will get a writ of possession that will usually direct the tenant to move out of the home in around 24 hours after the tenant gets served with a copy of it. However, the statute does allow the court to let the tenant remain in the home until trial if there's good cause for the tenant to do so, and the tenant is able to pay a bond of adequate security. This is rarely used, especially when you're dealing with tenants who are representing themselves in court. I think it comes up more often if the tenant is represented by legal services. But how I've seen this interpreted is that the judge will find out, the landlord's likely damages or how much rent the tenant owes, and then they'll set the bond at that amount to allow the tenant to remain in the home until trial. The unlawful detainer statute, requires the landlord to put the tenant's personal property in storage until there is a final ruling, if there's a writ issued at one of these temporary hearings. I will note that there's some conflict in Arkansas law about what is to happen with a tenant's personal property. There's another statute saying that Arkansas, considers personal property abandoned by a tenant if the tenant is behind on the rent in some cases. However, I would say that if you are filing an unlawful detainer case, you need to follow like what the unlawful detainer statute says about personal property, which is that the landlord needs to put it in storage until the case is resolved, or unless the tenant is just able to go ahead and get everything out. A writ of possession is not a final appealable order. So, many landlords will get a writ of possession at one of these temporary hearings, or if the tenant just doesn't file an objection, and then they'll simply non-suit the case or dismiss it without prejudice. And in most cases, that's not very problematic. It can be in the best interest of both parties sometimes because, it could be good for the tenant because the landlord won't end up getting a money judgment against the tenant. But many tenants who are evicted for non-payment of rent don't have the assets for a landlord to actually collect on that judgment anyway. However, a tenant with a good defense may want to push back on that for some reasons I will explain. So what happens after the hearing on possession? Most unlawful detainer cases don't proceed beyond this point, but they can, and they should proceed like any other civil case. And there are a number of outstanding issues for the court to resolve. The court needs to issue a final ruling on possession. If the tenant has filed any counterclaims, those need to be resolved. The court needs to make some sort of ruling on what's to happen with the tenant's personal property if it's still in storage. And the court needs to make a ruling on damages. So if the landlord wins the case, the landlord can get a judgment for rent and liquidated damages. So those are going to be, the liquidated damages are going to be the same as rent if this is a residence, 3 times the rent if it's a commercial property. But the statute actually allows for the tenant to get damages if the tenant is removed from the home while the case is pending, but then the tenant wins the case, at trial or whatever the final ruling is, summary judgment or whatever. So if the tenant wins, the tenant gets possession, and in theory, the tenant could get liquidated damages for any time that they were kicked out of the home while the case was pending. And I don't see this happen very often, but it certainly could happen because these cases move very quickly. And by the time that the parties go to a temporary ruling, they probably have not done any discovery or had a chance to do much with motions or anything like that. The unlawful detainer statute itself doesn't actually allow the parties to get attorney's fees. So I would advise someone on either side of one of these cases to file a separate claim for breach of contract, because that would allow them to get attorney's fees. Okay, here are a few defenses that come up in eviction cases. These aren't going to, apply in every fact situation, but I would at least consider these fact scenarios I've listed as red flags that the attorneys involved should look into. Some of the more common things that we see in my work are unauthorized practice of law. In Arkansas, the practice of law is limited to attorneys who have been licensed by the state. So if you're not a lawyer, you cannot go to court and file a lawsuit on behalf of someone else. That's called practicing law without a license. You can represent yourself, but you can't represent a company that you're involved with, except for some small exceptions if the case is filed in small claims court. However, eviction cases are generally going to be, unlawful detainer cases filed in circuit court. So the company would need to be represented by an attorney, or the case can be dismissed or struck because it was filed through the unauthorized practice of law. And I'm good on time, so I'm just going to talk about this a little bit more. An interesting thing about this is that, it's a procedural defect, and many of those can be fixed by just filing, an amended pleading or something. However, unauthorized practice of law cannot be fixed by amending the complaint, or just like, if a landlord goes to court and files one of these cases on their own for a company, they can't just, hire an attorney to get involved in the case and, fix it, because then the amendments won't relate back to the original filings, because the original filings are invalid. So you gotta dismiss it and do the whole thing over. So just avoid this whenever possible. The tenant could also raise a defense that the eviction is discriminatory in nature. Some of the ones that we see more often are tenants who are being evicted for criminal activity when they were a victim of intimate partner violence of some kind. This may violate the Fair Housing Act and the Violence Against Women Act in some cases. I see these less often, but they all happen. A landlord may waive or sort of sit on their rights when they know that the tenant has violated the lease, and this may make it difficult for them to enforce those rights later on. For example, if the landlord takes rent late every single month, they need to give the tenant some sort of written notice that they will no longer accept late rent, rather than just sort of surprise them by starting the eviction process for doing something that they've been doing for 6 months. Subject matter jurisdiction comes up often. Unlawful detainer cases should be filed in circuit court. Occasionally, a tenant may be involved in a bankruptcy case where there's some sort of stay going on that would stop the eviction from going forward. If the landlord is suing on behalf of a company, then that company needs to be in good standing with the state of Arkansas. Their franchise taxes need to be paid up, or they're not going to be able to use the courts to sue people until that's resolved. I will speak later about some issues with income-based housing, but if you're dealing with income-based housing, you need to be really careful that you have the grounds and that you meet all of the notice requirements for that housing program. And those will usually be like described in the party's lease, not always. But so tenants in income-based housing have a lot of defenses that other tenants may not. And also tenants have some rights after a foreclosure, assuming they are an actual, tenant. Here's some potential counterclaims. It's not exhaustive, just these are the ones we see more often. Tenant may file something for breach of contract, usually about a health and safety issue that the landlord has failed to address. Sometimes the landlord will remove the tenant from the home without the court's permission while the case is pending, in which case the tenant may file a counterclaim for forcible entry. There are a number of housing discrimination counterclaims that can be brought. There are ways to address these through government agencies such as HUD or the Arkansas Fair Housing Commission. However, you can also raise them as counterclaims within an eviction case, and you should when they apply. I'm not as familiar with these, but there is some work that's been done with the Arkansas Deceptive Trade Practices Act around habitability or health and safety issues. And I think that some landlords' attorneys have been found to be debt collectors for the purposes of like debt collection law. So a tenant could potentially have a counterclaim under this as well. Side note, you may have heard about something called criminal eviction in Arkansas. And this is not really an eviction at all. It's a criminal law called failure to vacate. Arkansas is the only state in the country with this kind of law. It's the only state in the country that criminalizes the eviction process in this way. And so what it does is a tenant commits a crime under this statute if they remain in the home after they get a 10-day notice to vacate based on non-payment of rent. I will say this law is very, very rarely enforced in Arkansas at this point. It is widely unpopular. Many prosecutors don't, they use their discretion not to enforce it. There are concerns about its constitutionality in terms of due process and other things. However, the current version of the statute, Arkansas has upheld that the current version is constitutional. However, there are some circuit court opinions that may be in conflict with that, but it was on the last version of the statute. All of that is to say, these cases can be messy, and most jurisdictions in Arkansas don't file them at all. But what happens if you are in a place that enforces this? Well, the tenant can be fined anywhere from $1 to $25 per count, and the tenant can have a separate count for each day that they remain in the home after the notice to vacate expires. There's nothing in the statute itself that allows the criminal judge to make a ruling on possession. So, you really can't use this to evict a tenant, although informally it does sort of function that way in the places where it's used, because the tenant will sort of feel pressured or coerced into moving. This is not allowed in HUD rental housing at all. HUD has determined that internally and issued guidance to housing authorities and other programs on this issue. So that if you're in Section 8 or public housing or something, they should not be using failure to vacate. And I would just say that if it's a failure to vacate case and the rent is based on the tenant's income, you should not proceed further with that. And the tenant should contact us because they may have a defense. If the landlord brings a failure to vacate case for an improper purpose, they may be, liable for a lawsuit for malicious prosecution or abusive process. And this doesn't happen often, but where it could come up is if the landlord wants to get rid of the tenant for some reason other than non-payment of rent, or if the tenant is actually current on rent, but the landlord maybe files paperwork with the prosecutor saying they're behind or something like that. But then they try to use this as a shortcut so they don't have to hire like a private attorney to use the actual eviction process. So just be careful with that. Okay, now I'm going to talk about habitability. What do I mean by habitability? I mean health and safety standards in rental housing. And you may have heard some things like, Arkansas is the worst place in the country to rent because we have no habitability laws. And we are quite behind the rest of the nation in that regard. We have the weakest ones, although the current state of the law is a little messier than you might think. Arkansas law creates like a floor of what people's rights are here, but not a ceiling. What I mean by that is that people may have rights under their leases or federal law that go above and beyond state law here. Let's talk about state law for a second though. So the default rule, caveat lessee, lessee beware or buyer beware. If you rent a place, it's on you to be an informed consumer and you take the home as it is, and the landlord is not liable if that home is unsafe for a human to live in. Arkansas courts, have kind of taken the position that this is the legislature's role, and if they want to create health and safety standards, the legislature needs to be, the body to do that, or the branch of government to do that. However, Arkansas does have something called an implied warranty of quiet enjoyment, which is different from an implied warranty of habitability. And it, for quite some time, has allowed tenants to move out at their own expense if the home is uninhabitable. And Arkansas has a relatively new statute that allows for that remedy as well, although this is not very helpful for tenants. In my experience, most of them want to remain in their homes and just want the issues to be fixed. Tenants may have more rights under their lease or their contract with the landlord. There may be city housing or building codes that give them some help, and they may have some rights under federal law. And so what I mean by this is, if in the lease, the landlord agrees to make repairs or agrees to be responsible for maintenance, then the tenant has, both parties have to follow that, and the tenant can enforce that against the landlord in court, just like any other time that somebody breaks a contract. Many cities, most cities of a certain size, have housing or building codes that require property owners to keep their properties safe, to meet certain standards. They're usually fairly basic things, running water, safe electricity, that sort of thing. And if the property owner does not do this, usually after some warning or warnings, the city can actually take action against the property owner to enforce this. Bigger cities tend to have more involved code enforcement departments, and they have officers who will go out and inspect and enforce these laws. Housing codes, there has been some creative advocacy in recent years that have allowed tenants to enforce these, but generally speaking, it's going to be the city that has to enforce the codes, not the tenant. So that's really between the city and the landlord in most cases. And if the property is funded by the federal government in some fashion, federal law may apply. In particular, if the property is income based through some kind of federal funding. So even if none of those things apply, even if you're just dealing with, private rental housing in Arkansas, if the landlord has no legal obligation to do a repair, but then they do it negligently in a way that hurts someone or harms someone, they may still be liable for that. Tenants who are having health and safety issues in their homes, they can and should call their city's code enforcement department to report those issues, to try to address them if the landlord is not willing to fix them on their own. However, what they should know is that Arkansas law doesn't prohibit the landlord from retaliating against the tenant for that. So that puts many tenants in a very precarious situation, because what can happen is that even if the tenant is like current on their rent, the landlord could just not renew the tenant's lease when it expires, and the tenant would then have to move or be evicted. And this is especially relevant if you're dealing with someone who has a month-to-month lease. And we didn't discuss this before, but in Arkansas, a lease is your contract between the landlord and the tenant. And leases don't have to be written down, as long as they're for like a year or less. But ideally they are, so the parties are very clear on what their rights are, but in many cases they're just verbal agreements that are like, the tenant gets to live in the property in exchange for this amount of rent each month. And this verbal agreement just renews automatically each month on a month-to-month basis. Okay, there are some unique issues for landlords and tenants dealing with income-based housing. The major income-based housing programs are going to be public housing, Section 8, tax credit properties, and rural development housing. All of these programs I've just listed are funded by the federal government. The federal government, like a federal agency, may give money directly to the complex, or they may give money to a local housing authority, which then distributes the money. It varies a lot by, what kind of program you're in. But across all of those programs, tenants generally have a lot more rights under federal law than they would under Arkansas law. And these rights should be explained in the party's lease. However, like if their lease is in conflict with these like federal regulations, then the regulations are going to control. Because these federal agencies are funding these programs, and that funding comes with a lot of strings that the landlord and the tenant have to follow, and that the property owners have agreed to follow in exchange for this money from the federal government. So as a practical matter, what does this mean if you're handling a landlord-tenant dispute? Some of the major differences are going to be that for most income-based housing programs, the lease has to be renewed. It has to be renewed unless the landlord has good cause not to renew it. They can't simply say, I'm choosing not to renew the lease, and then, you'll be evicted if you remain in the home. The tenant has to actually, breach the lease in some manner that's serious enough that the tenant could get evicted for it, usually. And that's the same standard that they would have to meet to not renew the lease. So holdover evictions just when the lease is expired and the tenant remains in the home, those should be very rare when you're dealing with income-based housing. And in most of these programs, the tenants have the right to an informal appeal of some kind before the landlord ever files an eviction case in court. And what that appeal will look like will vary based on what kind of program you're in. Generally, public housing has kind of the most extensive appeal process, and you have, a hearing before a hearing officer, almost like you're doing a Social Security case or something. In other programs, it's much less formal, and it's sort of an informal meeting between the landlord and the tenant where they have to, if the tenant chooses to go to that meeting, where they have to talk it out and see if they can resolve the issue informally before anything is filed in court. But if the tenant is not told about these appeal rights, like within the eviction notice, then the tenant might be able to raise that as a defense later on. So be careful in how you draft your eviction notices so that tenants are on notice about their appeal rights. And in these programs, there's something called the contract rent, for example, $1,000. And this is how it works in most programs. Tax credit properties are a little bit different. But in general, you're going to have the contract rent, and then the tenant has the tenant's portion of the rent, which is based on the tenant's income, and it's usually around 30% of the tenant's monthly income. The tenant is only liable for the tenant's portion of the rent. And then, like, some government agency pays the difference between the contract rent and the tenant's portion of the rent, and it pays that through something called like a subsidy or a housing assistance payment. And this might be your local housing authority that's making this payment. It might be HUD itself. It's going to be a government agency of some kind. And what I see go wrong in some eviction cases is that the case is filed and the lease is included with the original filings, but there's like no mention of the fact that the parties are using like the Section 8 program or some kind of income-based housing program. So it looks like the tenant owes the full contract rent, but they really don't. So in the Section 8 program, there's actually a separate lease addendum that applies to the parties, and it explains like the rules of the Section 8 program and kind of this idea that this is subsidized, this is how much the tenant is responsible for. And that lease addendum is going to be contained in something called the Housing Assistance Payment Contract. So if you're a landlord attorney, I would include that lease addendum with the lease when you file one of these. I know that I just gave y'all a lot of information. So here are some resources if you have questions about this. If you want legal help, you can get free legal advice online from Arkansas Free Legal Answers. I neglected to include a hyperlink there, but I'm sure that you can find it on the Arkansas Access to Justice Commission's website because they host this free service where volunteer attorneys provide free legal advice online. And both of the legal aid programs in the state represent tenants in various kinds of landlord-tenant cases. Also, we have special events at the Pulaski County Courthouse in particular. We have a number of special events across our service area where we will provide basic legal advice and information to landlords as well, as long as they meet our income guidelines. And I can be a resource especially if attorneys or court personnel would like to contact me with questions. I'm always happy to answer them. You may want to look up whether a property is covered by the CARES Act. That's the federal law I was talking about earlier that requires 30 days notice to vacate for federally funded properties. If it's a bigger multifamily property, you can actually look at this database. I don't believe this database is admissible in court, but if you're just doing research, see, all of these places in 72202 have some kind of federal housing subsidy or a federally backed mortgage that would require them to give 30 days notice to vacate. Fannie Mae and Freddie Mac, those are government entities that own a lot of mortgages. So, you might think that you have a mortgage through just a bank, but it's actually been sold to Fannie Mae or Freddie Mac. And if you're just like a person who owns a single family home, if you want to know if the CARES Act applies to your property, you can actually look it up on these databases provided by Fannie Mae and Freddie Mac. What is a little problematic with this is that it has to be the property owner that looks it up. The tenant can't look it up on their own. So if you're a tenant, it can be very difficult to know if your property is covered by the CARES Act unless it's obvious because it's income-based housing or it's a bigger place where you can look it up in this database. And in general, I would say that the National Housing Law Project is a wonderful resource as well. They're a national group that provides a lot of training and technical assistance on landlord tenant matters. And they have a publication called the Green Book that I look at several times a week and have for years, that goes into a lot of detail about landlord tenant law related to income-based housing. So if this is an area of law you practice, I would suggest getting a subscription to the Green Book by the National Housing Law Project. I think that would be well worth the money. Okay, we have a little time left and I would be happy to answer some questions. And I think that Edith may have some final things that she wants to talk about with CLE credit as well.
Yes. Well, first of all, thank you so much, Kendall, for a very informative and very relevant CLE. Yes, just to remind everyone, or if you're joining in late, I will be sending today in the evening an email. It will contain this PowerPoint presentation that Kendall will provide for everyone. And then it will also contain your certificate of attendance. Please fill it out completely. Don't forget to sign it. And then email it back to me. My email address is provided right here on screen. And please do so within a week. And I'll be more than glad to forward that to the Office of Professional Programs. And just remember, if you don't receive an email, it is because you did not complete the 60 minutes and we're required to monitor that as part of the accreditation process. And then lastly, if you, again, sign up under maybe a different account that you register with, or if you sign up under your phone, send me an email and I'll be able to link your time and to be able to account for the full attendance. And there were a couple of people that emailed me before the CLE and that had questions. I think there's some that were very much in depth and they're better answered through individual emails. So I'll forward those to Kendall and she will be answering those individually via email. But I have one right here. I know that you touched on a little bit during the presentation, but let me go ahead and raise this question. If you have other questions, please go ahead and put them under the Q&A so that we can answer them hopefully today. The question is, it comes from a Rent a House, is the name of the user, and it says, can a sole owner of an LLC file paperwork to represent him or herself regarding an unlawful detainer? And if not, why?
No. Not unless that person is a lawyer. And the reason is that, Arkansas limits the practice of law to licensed attorneys. So if you own a company and you're not a lawyer, like your company is is legally separate from you. So if you go to court and file a lawsuit on behalf of your company, you are representing someone else in court without a law license, and that is not legal. And the case could be dismissed or thrown out of court for that reason. Those sorts of cases are allowed sometimes in small claims court, which is set up and it's very informal and it's meant for people to, proceed without a lawyer. However, unlawful detainer cases need to be filed in circuit court. So that's why if there is a company involved, the case needs to be filed by an attorney. However, if you're just like a person, John Doe, and you own a house, you can file an unlawful detainer case in circuit court to represent yourself, because you're still allowed to represent yourself whether you are a lawyer or not. I hope that answers that question.
Thank you so much. And I don't see any more questions on the Q&A or on the chat. Do you have any questions that you want to raise? If so, please go ahead and put them in the chat right now. I have this other question. I don't know if you wanted me to raise it. Is this, I think it's a little bit of a general question, and I don't know if it's relevant, but it says, what education do police officers receive regarding landlord tenant law, if any?
I'm not sure about that. I saw that question before we began, and if I had to guess, I would say probably not enough training, but we would be happy to help with that. If any departments would like to give us a call, we would be happy to come talk to them to explain some of these issues. I mean, a lot of law enforcement officers seem to know not to get involved in landlord-tenant disputes unless there's a court order directing them to do so. But I really can't speak to what kind of training they receive on these issues.
Thank you, Kendall. And I think Ms. Teresa posed a question on the chat, and just wanting to verify whether the Green Book link that she provided here is the correct one. I don't know if you can see the webinar.
I actually did not provide a link to the Green Book, but I will work on that right now so that you have what I'm talking about.
Perfect, thank you. So we'll be sending that link along on this presentation. Are there any other questions? Okay, I think we have a question here. This question comes from Shawanda Clayton, and it says, what or who do I call if my landlord refuses to fix issues in my home and she is on Section 8 housing?
Well, it depends on a couple things. That's what lawyers always say when you ask us questions. But first, if you're on Section 8, I would call your Section 8 caseworker, because your local housing authority may be unhappy to hear that and may, make the landlord make those repairs. If that does not work, you may want to talk to your local legal aid program, which for this area here in blue, that's going to be Center for Arkansas Legal Services. For this area up here in orange, that's going to be Legal Aid of Arkansas. And you can just call us at these phone numbers listed, talk to an attorney over the phone for free. And if it's something that you need more than just some simple advice with, then we will do what we can to help you with that. You can also call your city code enforcement department, and they may take action on that. Although sometimes code enforcement departments are kind of reluctant to get involved in income-based housing. So it can be a little hit or miss with that.
Okay, Shawanda, I hope that answers your question. Does anyone else have any other questions? Okay, well, if not, I think that concludes our CLE. I want to thank everyone for making the time and being here with us today. Especially thank you, Kendall, for putting up this great presentation, very useful and relevant.
Thank you all so much. Have a nice day.
Yes, the recording will be available, and we'll be putting it on our YouTube channel, and we'll be sharing that also with the Center for Arkansas Legal Services so that they can provide it too on their YouTube channel. Thank you so much again. Have a beautiful day. Thank you.
Yeah.